This is the Chartered Institute of Arbitrators Young Members Group ADR World Tour, Day 2 of the India leg. The ADR rock stars from the Young Members Group of the Chartered Institute of Arbitrators have together curated this informative and collaborated journey of the ADR World Tour to promote ADR as an effective tool and to provide access to justice of understanding how ADR regimes around the world operate. A brief introduction about myself I'd already given. I'm Ishan Madan, a lawyer from Delhi, currently in the US, pending admission to the New York bar. I'm also the founder of Arbitration, a platform advancing research, dialogue, and thought leadership on the interplay between arbitration and insolvency. Now, before we move to the introduction for our amazing speakers today, I would first like to begin with some housekeeping suggestions. All the attendees are requested to use the question and answer button in the bottom ribbon of your screen to share your questions instead of using the chat feature. In the chats, though, please do drop in a hello mentioning where you are from. And also, I will be sharing some poll questions which will pop up on your Zoom screen. Please feel free to answer those with full anonymity. Those questions, the answers to those questions will be your contribution to a comparative worldwide study that will be published at the end of this tour. Must I also point out as a disclaimer for this particular session as well, that the views shared by the speakers today may not necessarily reflect the views of any organization, entity, or firm that they may be associated or affiliated with or represent. The views may only be academic for the purpose of discussion. Anything discussed here shall not be attributable to any related organizations or institutions unless the speakers or panelists otherwise desire or indicate so. Now, I welcome the moderator for the session, Ms. Jayara Sharma. Jaya is a fellow of the Chartered Institute of Arbitrators. She's also an international arbitrator and a mediator herself. Jaya is an American attorney and serves at various key positions in several international committees here in the US. Now, Jaya, I believe everyone is here. The floor is all yours.
Thank you, Ishan. So I would like to welcome all the viewers today. Namaskar to my Indian colleagues. Good morning, good afternoon, or good evening, depending on where you are tuning in from. We really welcome your participation, and we hope that you will find this to be a very informative session. So today we have a stellar panel of very qualified, highly qualified speakers with us. And in the interest of time, I won't give you a very lengthy bio about them. You can go onto the Chartered Institute's website and you'll see their detailed bios. So we're very privileged and honored to have Justice Ravindra Bhatt with us today. For those of you who practice here in India, you probably know him very well, but for the speakers, for the viewers in other parts of the world, Justice Ravindra Bhatt is one of the sitting justices on the Supreme Court of India. So welcome, sir, and thank you very much. I know you have a very heavy docket, and we appreciate your taking time out of your heavy schedule to come and share some ideas and thoughts with us today. We also have with us Professor Dr. Dilip Ukey, who is the Vice Chancellor of the Maharashtra National Law University in Mumbai. He's going to address some of the issues in mediation today from the educator's perspective. Next, we have Mr. Anil Xavier, who is the president of the Indian Institute of Arbitration and Mediation. And we have attorney Chakrapani Misra, who is a partner with Khaitan and Company in India. And he's going to talk about mediation from a commercial corporate counsel standpoint. We have Ms. Iram Majid, who will be addressing mediation and from the perspective of an ADR provider. So welcome to all of you. And as mentioned earlier, we're going to focus on mediation. I just think that this mediation in India has been, it's been a viable dispute resolution mechanism in the global economy, and we want to focus on what's happening in India right now. Currently, you have court annex mediations, and it seems that these have proven to be acceptable as a dispute resolution mechanism for family law cases. However, as mentioned also by the speakers in the earlier session today, in the area of commercial disputes, parties very rarely resort to mediation to resolve their disputes. So today we'll examine why mediation in particular is not used by parties in commercial disputes to amicably, expeditiously, and cost-effectively resolve their differences. What are some of the hurdles and obstacles which stand in the way of the acceptance use of mediation as an alternative to litigation? In domestic mediation, will India enact legislative changes to pave the way for private commercial mediation on a large scale? With India being a recent signatory to the Singapore Mediation Convention, what is the future of international mediation in India? It seems to be in the balance. In all, there are about 53 signatories and to the convention, and only currently 6 countries have ratified the convention, and India is not one of them. So we'll examine what impact this convention will have on the practice of international mediation as an ADR mechanism in India. Will India ratify the Singapore Mediation Convention? What challenges does the Mediation Convention pose for India? So I feel that the future of mediation in India is at the crossroads. Which path will India choose? Should it continue in the present and maintain the status quo, or should India see significant legislative amendments and judicial decrees which will propel mediation in India onto a new path? So as I mentioned earlier, we have speakers with different backgrounds. So to start off this discussion, I'm going to turn to Justice Ravindra Bhatt and maybe just ask a few questions to get an idea of what the status of mediation in India is as it pertains to court annex mediations. So Justice Bhatt, the floor is yours.
Good evening. Dr. Dilip Ukey, Vice Chancellor, Maharashtra National Law University. Mr. Anil Xavier, President, Indian Institute of Arbitration and Mediation. Ms. Iram Majid, Executive Director, Asia Pacific Center for Arbitration and Mediation. Mr. Chakrapani Misra, Partner, Khaitan, and Attorney Jayara Sharma. The first question, which I believe has been addressed to me, is the role of the Supreme Court Mediation and Conciliation Committee and its evolution in this journey of mediation. This committee was set up in 2005 to give impetus to the mediation initiative in India. Initially, Justice S.B. Sinha, or rather the late Justice Sinha, gave a tremendous boost to mediation and worked tirelessly for it to bring mediation training to remote parts of the country. After he retired, the mantle was taken over by Justice Ravindra and later by Justice Madan Lokur, and the job continues under the chairmanship of Justice Nariman and Justice Kaul. All these have, on a continuous basis, spearheaded the movement. The work that they did and continue to do by involving experts in the field of mediation, to train mediators, stipulates standards and guidelines for training of mediators, and set up the Supreme Court Mediation Center has been extremely productive. The path shown by the SCMCPC, as it is called, has led to the creation of design of courses and manuals for training of mediators, mediator trainers, the role of referral judges and their training, evaluation of mediators, and so on. Its achievements, and they are quite formidable, have been set out in its website. As of 2016, It reveals that 304 40-hour mediation training programs were conducted, a number of awareness, referral coaching and mentoring programs, and no less than 379 judges training programs were undertaken for referral judges. The MCPC has with it about 150 trained mediators, not only in Delhi, but in other states. As of 2016, over 375,000 cases of the references received were recorded as settled in its website. Alongside the initiatives, or even parallelly with it, of the MCPC, when it was evolving into what it has become, the other court-annexed centers were also set up. They were pretty proactive. Samadhan of the Delhi High Court always comprised exclusively of lawyer mediators who too receive 40 hours training, and each of them is allowed to mediate by himself or herself after being a co-mediator in about 10 cases. It has also similarly notched up impressive statistics during the last 15 years. It has several hundred mediator trainers. Many of them have been trained overseas and are also accredited members with foreign institutions. Like Delhi, which has 12 other mediation centers, court annexed centers, Bangalore too has a very impressive record. Besides these, for many years, the mediation movement, if one may so characterize it, has resulted in several district courts setting up mediation centers annexed to them. The MCPC and other centers repeatedly emphasize that the mediation process places the litigant at the heart of the concern and therefore crucially stresses the importance of the role of referral judges who can spot what can be and what should be referred to mediation, and also equally importantly at what stage. Now, having said that, I also feel that it is important to somewhere launch the second phase where mediation takes off in a more popular manner and it becomes a part of the popular psyche. We have, as of now, excellent court-trained and court annexed mediation center trained mediators. But I think if we are to deal with and tackle a large number of pending cases, typically those which are causing clogging in the court dockets, there is need to train even more mediators. And we need not confine to lawyers. Perhaps we have to go beyond them. And I'm not looking at big value, big ticket arbitration or mediation or disputes. I'm looking at what typically clogs the courts, which are small disputes and which require equal attention if you want the larger cases to be taken up faster. So I think it's also time that we focus on how to maximize our training effort and initiative. And I'm sure the MCPC will do its best to make mediation even more popular now that there is a mandate in the new act that the Commercial Courts Act, that mediation should be resorted to before a litigation is effectively launched. I'm sorry, I've lost you. I can't hear you.
I'm sorry, I muted myself so that there's no background noise, to minimize background noise. So Justice Bhatt, you make a very good point where you talk about how it's up to the judges or the justices, or let's say judges, the arbiter in this situation to realize at what stage and at what type of dispute can then be amicably resolved through mediation, perhaps. So in India, it appears from my understanding and being in India in 2015 at a India Pacific mediation summit, that you have most of the court referred cases are family law cases. And you mentioned earlier that perhaps there's need then also to refer commercial type cases. What type of commercial cases do you think would be amenable to mediation to also unclog the court's dockets?
See, there are, I'd first begin by saying that in 2017, the central government set up a committee to suggest methods of reforming arbitration practice and ensuring that it's more effective and speedier. This resulted in a report which is focused on two broad and main areas. One is to how to really tighten up the arbitration law and bring in some kind of timelines and plug the timelines which existed, which has now led to some amendments. And the second part was also making a strong pitch. I happen to be a member in that committee. The report made a very strong pitch for mediation and a separate law for that, but that would be another section as I understand. Typically, I'm of the opinion, and that committee interestingly had made recommendations with respect to mediation in commercial disputes, which went to arbitration. A large part of the committee's task was to suggest reforms in institutional arbitration and how the way ahead with respect to reforms in that segment and standardizing the institutional norms. So as part of that, there's an entire chapter devoted to the necessity, not just the need, the necessity of factoring in mediation as part of the ADR at the beginning or at the appropriate stage. You have the MedArb option, and later, if necessary, the MedArb Med, the MedArb Med or the Arb Med option. So all these were explored, and a strong recommendation was made that every institution should have a mediation center annexed to it. Otherwise, in my experience as a judge in the Delhi High Court, who has also dealt with a large array of commercial disputes and IPR disputes, I feel that practically there can be very little that is taboo in mediation. Typically, one can have mediation in, and at least in Delhi, and perhaps even in, I've seen instances in Mumbai and even in Gujarat, the property disputes, contract claims and compensation, money claims, corporate disputes especially, and there's a typical kind of corporate dispute which involves families also and cross holdings. Apart from that, simple corporate disputes, damages in IPR disputes once infringement or liability is determined, etc. All this can safely go in. I would also add to that list the ever expanding and exploding species of litigation, which is Negotiable Instruments Act. Now, these are, we have no less than about 4 million cases, cluttering up the courts at what is often lost sight of by lawyers who do not practice in the criminal side is that a check bouncing has led to criminalization. And that has massively jammed up our court dockets. Delhi at one stage contributed a lion's share to the size of this pendency. Now, mediation has been very aggressively, advocated. What we really need is an infrastructure and training in that. That apart, the decision of the Supreme Court in 2010, AFCON's infrastructure, has laid out very clearly what cannot be mediated, which would be, and they have given these instances, representative suits involving public interest or numerous persons, not all parties before the court, disputes pertaining to election to public office, suits for grant of probate or letters of administration, cases involving allegations of fraud, fabrications of document, forgery, and some such criminal behavior, claims against minors, DTs and mentally challenged persons, and suits for declaration of title against government and prosecution of criminal offenses. Now, these are taboo, so definitionally everything else ought to be subjected to mediation. But I would just add one important caveat, which is that proceedings which are in rem, in the sense that which are for the public good, for instance, environmental litigation, which involves loss of habitats and livelihoods for millions, or damage to the environment, or some such thing like in utilities and regulation which concerns tariffs or policies concerning policies concerning electricity or telecommunication. This should not be per se referred to mediation, but though there is a certain subcategory of litigation where one service provider claims damages against another, which is subject to the jurisdiction of the court or the concerned tribunal, that can be subject to mediation. And of course, there's a very important segment, the consumer disputes. These two can go for mediation. So I think all these are the categories of cases which can easily go in for mediation.
So do you find that the court annex mediation has provided better access to justice, because justice delayed is justice denied, right? And with mediation, particularly, I found that in some of the mediations I've done, in cases we had foreclosure mediation when homes were being, during hard times, the financial crisis, a lot of people couldn't pay their mortgages and their homes were going to be foreclosed. That the mediation then also provides a venue for them to actually come face to face with the financial institutions to vent their frustration and so on. So do you think that mediation then provides that kind of a forum too, not only to get this dispute resolved amicably, but also an opportunity to promote, better, effective justice in a way?
You see, that's the interesting part. Mediation definitionally would mean that this is a different kind of thinking. You're not in the frame of mind where you want to get the dispute resolved on the merits, rather that you are at the center of the process, and it is your autonomy, your choice whether to in fact, you create those choices and come to a mutual agreement with the help of a third party neutral. So definitionally, this actually provides a better control, a better option to the party than a resolution through court, because court means typically there are layers of litigation. You have an appeal, then a further appeal, and possibly you end up in the Supreme Court. All this is adding up to delays. So therefore, in terms of those who opt for it, it definitely is a ray of hope. And those who are successful at it, it's 100% access to justice. But having said that, there would be issues in the sense that the mediation movement though it has taken strong roots, it has not spread to the extent one would wish it to, in the sense that you should look at mediation as the first stop rather than litigation. And today we have a situation which is largely the reverse, that you first rush to court, then the court refers you to mediation. So in that sense, there is no mediation culture per se in the psyche of the people. That has to be inculcated. And I suspect it will take a little while. It cannot be done overnight. It's not a very easy process, given the challenges that our country faces. Therefore, this culture is sought to be fostered by the amendment, especially in commercial court, in the commercial disputes, by the Commercial Courts Amendment Act of 2018, which mandates that you, before moving the court, you must try out mediation, the pre-litigation mediation. And now the rules have factored in a period of 3 months. This is Section 12A of the Commercial Courts Act. Well, these have been subjected to contrarian interpretations in different courts. So one hopes that there's a resolution to it and a cap to it. That's one big step. I would say a welcome move, but segmenting it and confining it to commercial courts per se perhaps is not necessary. We should actually be looking at a wider spectrum of disputes where everybody thinks of mediation as the first stop for a dispute resolution rather than the court, instead of going first to court and then being referred. That's my observation. Likewise, we have other enactments, for instance, the Micro, Small and Medium Industries Act that also mandates conciliation and thereafter arbitration. We have a very age-old provision of conciliation in the statutory conciliation in the Industrial Disputes Act. Even today, a workman or rather a trade union or a group of trade unions or a management cannot go to court directly. They have to first approach the conciliator. And if the conciliation fails, then and then alone are they permitted to go to court. In fact, what is now forgotten is that some of these conciliations resulted in awards and which continue to bind the banking and insurance industry even today. In terms of wage settlements in the early 50s and 60s. The structure, the pay structure, the hierarchical promotion and other terms and conditions continue to be the same. So there can be success stories, and there is some, and this is not anecdotal, there is some record, there's some empirical study showing that in IPR disputes of late, mediation has been pretty successful. So these are my observations.
Thank you very much. You've given us a lot of very interesting ideas. What I'm going to do is turn to Mr. Anil Xavier to sort of comment. Anil, can you comment on some of the issues that the justice identified? I know you're very passionate about mediation. So can you just give a few comments, please?
Thank you, Jaya, and it was wonderful to listen to Justice Bhatt, because that is the view that we were hearing from the judicial point of view. But considering the topic, because we were looking at the position where India is at the crossroads. See, fundamentally, I think, the judiciary has done a wonderful job in promoting mediation through court annex systems and making it popular to the people about the process of mediation, because by mandatory process, if people are not convinced or if people are not ready to voluntarily accept mediation, there could be some ways in which they are shown how mediation is. And that was a perfect example of how mandatory mediation was introduced by the courts and asking them to go for mediation and experience it. And if it's not successful, come back and litigate. And if you're successful, you get back your court fee as an incentive. Process, or it is a wonderful way in introducing mediation to the public. But what I feel personally is, when the child is growing up, you need a hand-holding. So when mediation was growing up, there was a perfect hand-holding by the courts. But when the child has grown up, then you need to leave the hands and allow it to grow individually. So it may look controversial, and when Justice Bhatt is here to say that please leave us alone, or please leave mediation on its own feet to grow, that is what I am looking at as a crossroad. Because unlike, suppose you compare arbitration and mediation, because I'm talking at the user perspective, because when you're talking about arbitration or arbitration, there is no confusion about what arbitration is. Whether it is domestic, you are doing arbitration on issues which are arbitrable, and whether it is between two parties, one from a local jurisdiction and one from international jurisdiction, it automatically becomes an international arbitration. So there is no much difference between the arbitrability of a dispute with respect to arbitration. But when you look at mediation, it's a total confusion. Because if you're looking at mediation in the Indian perspective, you have mediation which is done under court annex procedures, where you go to court, you are referred back to mediation under Section 89 of the CPC. Or as Justice Bhatt said, you have the Commercial Courts Act, where you go to court, where you do not have an ADR clause, you go to a court which is a commercial matter, and the court mandatorily refers you to mediation. That is one way of doing it. And if you look at private mediations, you don't have a mediation law right now, so you mediate under the Arbitration and Conciliation Act, and whatever the settlement agreement comes out of that, it becomes a deemed award under Section 74 of the Arbitration and Conciliation Act. And if you look at Lok Adalats, the matters are either pending in courts or new matters, they can go to the Lok Adalats, and whatever outcome comes up, it becomes like a judgment of a court. So here you need to look at the process, not only the process but the outcome. Under the Lok Adalat or the Legal Services Authority Act, once a matter is settled, it becomes a judgment of the court. Under court annex system, once it is mediated, it comes back to the court and becomes a decree of the court. Under family court, if it's a conciliation and it comes back to the court and it's made as a judgment. Under the Arbitration Conciliation Act, it becomes a deemed decree. So the outcome and the status is totally different. So the user is totally confused, because if you look at the Singapore Convention, an outcome which has got a mediated settlement which has got the effect of a court judgment, it's not recognized under the Singapore Convention. If the outcome is a deemed award, arbitral award, Singapore Convention does not recognize it. If it's a matter which relates to family disputes, consumer disputes, employment disputes, or such disputes, it is not considered under the Singapore Convention. So what does the mediation, or what are the disputes that can be considered as mediation, pure simple mediation? See, it should not be, the outcome should not be considered as a judgment of court. The outcome should not be considered as an arbitral award. The outcome should not be enforceable as a decree. So pure and simple agreement between the parties signed by the mediator. These are the mediations that are considered by the Singapore Convention. So this is something which is totally rattling, because when you do mediation in India, if it is not court annex mediation, you are doing private mediation. For the purpose of enforcement, you do it under the Conciliation Act, because the outcome gets the status of a decree. But the same parties, if they want to do international mediation, a cross-border commercial mediation, they can't do it like that, because they want a simple arbitration, a mediation outcome, settlement agreement under the mediation outcome. And we do not have a substantive law to give enforceability to if it's done in India as a domestic mediation settlement. So we are in real crossroads, in the sense, if we have signed, we are signatory to Singapore Convention, but we have not ratified it because we do not have a substantive law which will uniform the outcome of mediation in a single bracket. And unless the mediation concept is bracketed under a single concept, pure and simple mediation, which do not have the backup of court for enforcement, which do not make it as a deemed decree or an award, a simple mediation with the stamp of the mediator, making it eligible for enforcement under a separate regime, which can also be enforced under the Singapore Convention if it is a cross-border dispute. Only if we make such a distinction, make the mediation process a unique process which do not have any other bindings, only then I feel the business community or the commercial disputes will embrace mediation, because arbitration is pure and simple, even though it has its hurdles. But mediation is always considered by the business community as a less privileged cousin of arbitration, because it is meant for the poor, it is meant for family disputes, it's meant for somebody who cannot afford litigation. So as far as the commercial party is concerned, he has got a battery of lawyers in-house or external. He can approach the courts. Access to justice is not that difficult for a commercial or a business house. So he considers that, see, the poor people should go out and mediate, but rich people like us should go and litigate. So this distinction as mediation as a poor cousin of arbitration has to be removed. And if it needs to be removed, it should be let free, and it should grow on its own. And the hand-holding, I think, should stop now. That's my view.
I might just make an observation.
Please go ahead, Justice.
At this moment, I think Mr. Xavier probably, we are not speaking at cross purposes at all. If you noted what I said was, there's a need to bring mediation into the consciousness of the people, and two, that it is important to go beyond and get in others and not just lawyers as mediators. So I thought that was quite a broadest hint, that's the broadest kind of hint that I could give to say that it should or should not be part of the code. I do recognize that. But I think what Mr. Xavier says is probably the real rub of the matter, in the sense that the consciousness of the Indian people appears to be, or that's the way we read it, and that's where we as a informed community have to disabuse them or educate the largest number of people that every outcome which is every outcome of a dispute resolution mechanism should be binding as an award or a decree of the court. It need not be. And mediation typically is one where it does not need to be binding in the sense that it is part of a court decree. I think that is something which has to be really disseminated, and I can entirely agree with him because mediation is different. Yes. Sorry, that's all that I wanted.
Well, thank you. That was probably something that you sort of clarified, and I think it was very well put, because that's how it is here in this country too, where mediation is seen as a stepped upon child or a stepchild and a stepped upon child. And people disputants still prefer to go to arbitration than to mediation. And you mentioned, you have these tier clauses where you say, first, let's try mediation. And if that doesn't work, we'll go to arbitration. Well, in many times, instances, parties will say, okay, our agreement says we have to mediate, let's mediate. But they're not doing it. It's all pro forma. They're not doing it diligently with the idea of, I've been in situations as a mediator where I've had to explain to them certain issues can be resolved between you here, and then the issues that you cannot arrive at an agreement, go litigate. So anyway, this is very interesting to hear that this is a global phenomena in mediation. So I want to now hear from Mr. Chakrapani regarding the corporate world. When I spoke with some corporate counsel a few years ago when I was in India and asked them about mediation and as an alternative dispute resolution mechanism and how effective and efficient it was, they sort of scoffed at the idea. They said, alternative? No, we don't want anything that's alternative. We want the real deal. So litigation for them is the real deal. So Attorney Misra, can you address mediation now from the perspective of the corporate world? Some of the clients
Sure. Thank you so much. And before I begin, I just wanted to express my gratitude to the organizers for inviting me on such an august panel and to share the stage with Justice Bhatt and other honorable speakers. So thank you very much for that. Also, I wanted to point out that my job has been already done by Justice Bhatt and Mr. Xavier. He has already pinpointed both speakers have pinpointed as to what the problems are. I'll try and nuance it more from the corporate commercial disputes, high-stake corporate commercial disputes, and from my experience for last few decades about dealing with the corporate commercial world and how they perceive mediation and where they stand today. So the perception today has improved, no doubt about that. However, it still remains by and large compartmentalized by what was mentioned earlier as alternative dispute resolution mechanism. So this alternative itself is a big hurdle. Second hurdle that it poses is that the question that you are faced with, under what law? Then you go into the lengthy discussion of saying, of course, I'm not talking about Commercial Courts Act, which have now the amendment has come for pre-litigation mediation. But before that, you have to launch into a lengthy justification that Honorable Supreme Court has given some judgments, and then you take them to all that thing, and then you say, no, actually, once you settle it, you will come to court, and then it will be, or you can, it will be a valid and enforceable agreement. Then the question again is put by a counsel, okay, when I go to my management, when I go to this thing from the party's perspective, what do I tell them? That what exactly, what kind of umbrella enforcement is going to happen? Suppose I mediate, you explain to me how mediation works. Very well. Now, after I have this mediation done, I have an agreement in which we sign between the parties and the mediator. Where do I go to enforce it? How do you enforce it? Will it become an arbitration award? No. Will it be a decree? Certainly not. So then how do I enforce it? So that is the primary reason why the complex commercial disputes are not being referred to mediation. That's one part. Second part is also a bit of a cultural issue, which Justice Bhatt referred to. And quite rightly so, because our mindset is still very adversarial. We look at it, okay, am I going to win this matter, or am I going to lose this matter? That's how corporate world perceives it. So again, there is a question of awareness to be imparted and to be told to people, to be told to this world that, look, you can have a win-win. You don't have to win at the cost of somebody else. So that's that's perception that is a problem. That's an issue. Last part that is, again, I mean, it's related to the first points that I made, is again the very there has to be an effective way of enforcing these agreements. So once we have a mediation, once we have a mediated agreement, that needs to be enforced. And for that, it has to be a streamlined process. It can't go back to enforcing a contract, which means that the parties will go back to court and again start litigating. So these are the few things which are still preventing corporate world from coming into and mediating their disputes rather than going to this thing, taking it to the other streams. That's where the problem is.
So do you think then that some kind of legislative or changes have to occur so that mediation then is seen as a mechanism, dispute resolution mechanism on its own, and it's not tied to the whatever settlements that arise out of a mediation? It's not tied to an arbitration proceeding or as an award or a court decree. Do you think that that's how it's done here in the US? It's every state has their own mediation law, and it's enforceable and it's confidential. We go to court in the event that the parties don't abide. If there's a breach of the settlement agreement, then you go to court to get it enforced. But so do you think then that, Anil, you mentioned this too, that this is not part of it's part of the arbitral proceeding rather than a standalone process? So would you have to enact any kind of legislative change to allow this?
In my view, most certainly, that will help. I mean, I say it with responsibility. I know that by very concept, mediation should be left alone and not be guided by a very strict step-by-step legislation. However, there has to be some umbrella framework, most certainly. And more importantly, what we need is a very effective way of enforcing the mediated settlement, because that will clinch the deal. As we discussed earlier, that when it comes to a decree, subject to going through all the appeals and confirmation by Honorable Supreme Court, once it is a decree, it's a decree. So an arbitration award, once it challenge process is over, it's an award. Similarly, mediation, once a mediation agreement is arrived at, it should have some finality and it should join the mainstream of execution rather than again being open to the court process. So certainly a legislation will help, in my view.
So one last question for you before I turn to some of our other speakers here. Attorney Misra, you mentioned that we need to raise awareness. How do you propose to go about doing that? In what form? I mean, here in the US, the in-house corporation counsel are the ones that make the decision as when a dispute arises as to the type of they're going to use or mechanism they're going to use to resolve the dispute. So it's done by in-house counsel. They may have outside counsel. They will go to them and say, we want you to litigate this with for us, or let's go to arbitration, or let's do mediation. So how are these sort of decisions performed in India and in your corporation, the corporate world?
So I'll answer the second part first. How it is done is a simple, straightforward process. When it comes to an agreement or when a deal is being made, the clause that talks about dispute resolution is always drafted at 3 a.m. in the morning. And it is mostly a cut, copy, paste from the earlier agreement, where it is bodily picked up and said, okay, there will be an arbitration, or there will be courts and so jurisdiction will have exclusive jurisdiction. And it is a boilerplate clause that often gets produced. And this clause is only taken into account when there is a dispute. And that's the time parties start debating, oh, did we do this? We should have done this, and so on and so forth. So this is how it happens actually. How we can change it, the first part of your question, how we can change it is a lot is happening already by creating awareness. And that's a very long process. And it's like there are no easy ways. And if arbitration has taken us 50, 60 years to come to where it has come, mediation is also going to take time. But key remains the awareness. And once we are able to convince the corporate world that actually mediation is maybe answer to most of their dispute resolution needs, we will be home, because mediation has its own settled advantages. It's quicker, it's cost effective, and it leaves a very nice atmosphere around once parties have settled their dispute. And I go a little further and say that even in my experience where parties have mediated and it has not been successful, a lot of groundwork was done, which ultimately resulted in dispute being resolved after going to court process, etc., but halfway through. So mediation has its virtues, that those virtues need to reach the real deal makers. There is no other solution to it. There's no other quick magic wand to it.
So thank you very much for those comments and your insight. This is a very good opportunity now for me to go to the Vice Chancellor. Thank you very much. I've observed you sitting very quietly and listening to this conversation, but now I want to draw on your insight and your expertise, because a lot of changes that have occurred in the legal profession here is as a result of the younger generation of lawyers that are coming into the field. And when I went to law school, mediation was something that was really never talked about much. There was just mention of it. But what I'd like to know now is the role that you as an educator are playing or can play in how the perception of mediation can be changed, and how new practitioners and in the legal field as well as in non-lawyers, how can they be brought into the fold so that the practice of mediation now can flourish? So please, the floor is yours. Thank you.
Thank you. Honorable Justice Ravindra Bhatt, Mr. Anil Xavier, Mr. Chakrapani, Misra, Ms. Jaya Sharma, my colleague and well-wisher, National Law University, Mumbai, Ms. Iram, Majid, and all other dignitaries and participants. Very good evening to all. At the outset, I thank Ms. Iram and organizers for giving us an opportunity to interact with you and share a few thoughts about the theme. As we know that disputes which are inevitable in any of the society, which might arise amongst the individuals or within the individual. When they arise within the individual, yes, a remedy could be, a prescription could be, a meditation. Whereas if they are amongst the individual, it is a mediation as such. Nevertheless, an ideal dispute resolution method has to be quick, a cheaper one, a fair one, a non-violent one, and we shall maintain the dignity as well as shall preserve the relationship of the parties as well. Any method of dispute resolution which respect these values can be considered as just, reasonable, and legitimate. So if litigation can respect all these stated ideals, then it is appropriate to use litigation. However, we know that litigation has by and large failed in delivering its promise. One of the main reasons for the failure of litigation is the adversarial method or adversarial mindset. The prospective lawyers are trained in law, logic, and arguments. They are trained to defeat the other party at any cost. Somewhere, values of humanity and compassion are lost from the traditional legal practice, is lawyering. The law universities and law schools shall take the blame for collapsing the justice system by producing such lawyers or judges. A law university or law school of the 21st century need to learn from this, and that's why we are learning from this. They need to imbibe the values of collaborative lawyering among the law students. It is easy to train the new breed of lawyers than the seasoned lawyers who are deeply ingrained in the adversarial approach. How the law schools take on this challenge will define the future of the justice system in this century. As a Vice Chancellor of a comparatively younger law university, I can say that our law school is taking all measures to fulfill its institutional social responsibility. In the last academic year, we started the Asia's first master's degree in mediation and conflict resolution, which is open not just for lawyers, but for graduates from all disciplines. The idea was to contribute to the inclusiveness and diversity of the mediators. The ADR centers worldwide end up focusing more on arbitration than mediation. The university consciously segregated arbitration from mediation and launched separate research and training centers. Our Center for Mediation and Research and Center for Arbitration and Research are doing such a marvelous good work with the international community. We also have a separate center for clinical legal education, which focuses on training of paralegal, lok adalats, and legal awareness, including mediation awareness. We also have a student-led ADR society, the focus of which is to train students and facilitate their participation in mediation, negotiation, and client counseling competition. It is a matter of great pride that our students have won laurels of CDCRC Vienna, ICC Paris, INADR, amongst other international reputed competitions. In fact, the Maharashtra National Law University Mumbai has its own flagship mediation and negotiation competition, that is Mediation Bombay, of which Ms. Iram Majid was also part as a judge of some rounds. And very recently, we successfully concluded its second edition online. Of course, because of pandemic, this year it was online. One of our another initiative is Meet the Mediator series, which we invite the seasoned mediators for conversation of their experiences with mediation. The idea is to inspire the new breed of lawyers. The ultimate aim of our law school is to ensure not only justice, but also access to justice. It will be possible when all the stakeholders work towards the mission of promoting mediation. However, I must caution that mediation may meet the same fate as of litigation. If the adversarial mindset is not abandoned, at the cost of reputation, I emphasize that initiatives by the law school in promoting mediation will be truly a game changer in coming days, in future time. Thank you.
Thank you for these wonderful comments. I had the pleasure just a few months ago to be on the ICC panel as a judge, and I was very impressed. I think I had the pleasure of judging 3 teams from India in the moot mediation competition, and I was very impressed by them. So I'm sure you've done a lot to promote mediation and also to provide a change in the mindset, because I think that is what is needed, because in today's pandemic world, there's a lot of chaos and conflict, and this might be a way to, when you're educating the young generation, might have a different mindset. So with that, I'm going to turn to Ms. Iram Majid, who is the Executive Director of the Asia Pacific Arbitration and Mediation Center. So could you please inform us what your perspectives are on how ADR providers can promote mediation, a better understanding of mediation, and what your role is to ensure that mediation as an ADR mechanism is being resorted to in resolving disputes.
Thank you so much, Jaya. First of all, I would like to say thanks to you for inviting me. And I would like to say thanks to Justice Bhatt for coming and accepting the, being a speaker. And I would like to say thanks to Mr. Anil, Xavier, Mr. Chakrapani, and my my friend, Mr. Dilip Ukey. And also I would like to say thanks Ishan and Brian and entire all the coordinators and everyone behind this entire endeavor for making these kind of sessions like on the mediation and the arbitration. And see, I'm listening, like all the people have covered most of the things. So with me, it's left only about talking about the institutions. So I will be telling you that what is the role of like me, an institution, in promoting ADR and the arbitration and mediation. So I must say that institution is not only playing an important role to promote mediations, but we have a responsibility to bring mediation to the next level. This I must say. And see, with the institutions, what is the main benefit to having an institution and how they are promoting mediation? See, with the availability of pre-established rules, with the help of, which helps the business community and stakeholders for trusting the entire mechanism. And with the help of, like, we have a beautiful hybrid and smart clauses in the rules. And see, I would like to say, and I say it again and again, that like we started Arbitration Act in India in 1940. And thereafter in 1958, we have a New York Convention. And still we are putting lot of efforts to bringing, institutional hub for the arbitration and bringing that culture and shifting the culture from ad hoc to institution. So I think that institutional mediation is very necessary otherwise. And otherwise we will be in the same trap for the mediation also. If we will be not providing support, and institution will not be coming forth to be like a great savior for the mediation. And the good thing which I feel is started in the mediation is like it is started in a very structured manner. If you see for the arbitration, see, in spite of having New York Convention, in spite of having model law, in spite of having so many things we have, even then we started with the ad hoc first. And now we are moving to institution. But with the mediation, if you say with the help and support of the court and the court annex mediation, that gives a culture of, institutions, centers. We have different various centers, the beautiful centers in the courts, and which providing, support for the mediation to the users and the stakeholders and the business communities. And so if you see, the mediation is growing in a different way. Mediation is coming from as an institution, itself as an institution. And so this is the change which I feel, and I'm very happy and I'm very confident that mediation has long way to go, because in commercial, if you see the arbitrations and all in the institutional arbitration rules and everything, we have only commercial disputes we cover, but mediation has a big canvas. And if you see the rules like APCAM, ICC, WIPO, CEDAR, they're having very prominent rules helping in promoting mediation extensively. And institutional also provides the parties to selection of the neutrals. So suppose many times what happened, the parties in mediation, the private mediation especially, they're unable to appoint an appropriate person or the subject expert or the domain expert. So in that case, the institution can provide them and support them for the selection of mediator. There is no hassle-free selection. You can go and you can ask, see, this is the dispute and we want to select. In an institution, you will be having all the kind of experts, you can be selecting them. And moreover, you will be having an admin support and the case manager, and a lot of supports are there with the with the institutions which we are promoting mediation in those supports. And talk about the pandemic, and during the pandemic, if you see, the entire process is being shifted online, and this is just because of the institutions. If you saw CIAC, if you see AppCam, if you see ICC, if you see IIM, they all have changed their rules, and they immediately shifted from offline to online, and they provided different guidelines. We follow UNCITRAL technical notes, and we follow different guidelines for the online. This would have not possible if it would have been done through the private users, or if it would have been done ad hoc mediations. Why? I must tell you that, see, when we are following certain guidelines in the online mechanism, so we are very confident that we are secure the privacy. We are secure the privacy, and the confidentiality should be maintained over there. But if you see that if the people are going for the private mediation with the ad hoc mediator, so they will be they will be having a lot of doubt for the process and the procedure, because there will be no confidentiality, and those kind of clause will be maintained. So if you see the entire what you call the institutions, so they provide rules, they provide case managers, they provide even they provide the coaches as well. Suppose the people who are not aware about the mediation process, so the institution provided the coaches to guide them to come and to they will make them aware with the entire mediation process. So we provide them coaches, admin support, easy communication, trainings, camps, and lot of community mediations mechanisms, so that it should go to the root level. So this is what the institutions playing a role in mediation promotion.
Thank you for outlining all the benefits of having institutional mediation. And in the interest of time, I mean, we could go on talking, but we don't have much time left. And in the few minutes left, there are like 7 questions in the chat box, and I want to answer some of those questions so that our panelists can respond to some of those questions that our viewers have asked. So there's one question here which I thought was very interesting, because this is where public mediation comes into play. I have done a lot of that for government entities to bring about peaceful settlement of community type disputes. So here's a question. It says, do you think the farmers' issue should have been mediated and hence been resolved earlier and more effectively? Who would like to answer that? Justice Bhatt, would you like to respond to that? You are muted, sir.
I don't want to respond to that.
Okay, so I know this is a politically charged question. I will let anybody else on the panel, do you wish to respond to this?
No, maybe I'll take the question, Jaya. In fact,
okay.
See, it technically it would look like it's a good dispute that could be mediated, because ultimately you don't hurt the feelings of anyone in mediation, and you try to bring out a level field where the interests of both parties are taken into account. So ideally, I would say the farmers' dispute is an ideal dispute that should be mediated. And any other adversarial system of, see, fundamentally what we say is in mediation we don't look at who is right and who is wrong, but we look at what is right. So the best option for both, I think, the farmers as well as the government, is to find out what is good rather than finding out who is right and who is wrong. So I feel it's one of the most ideal cases which should go for mediation.
Thank you. So here's another question. It says, commercial disputes pre-litigation, could not steps be taken to rope in mediation institutions rather than solely routing it through the Legal Services Authority? If so, what could be an ideal blend of both the national and state legal services authorities with that of institutional mediation? Anil, would you like to respond to this?
There are two limbs to that question, Jaya. One is, see, if you're looking at mediations or institutional mediation through the Legal Services Authorities Act, see, that will be confined to purely domestic matters because it automatically converts itself to a judgment after the resolution is made. See, one added to that, what I would like to add is, see, one way of reducing the court dockets is to give a alternative to the people to access to justice before entering to courts, because having entered courts and diverting them to mediation and ask them to resolve it is one way of reducing court dockets. But the better way to do it is to have a sieve system where you enter the funnel. Before you enter the funnel of litigation, you have a sieve where you look at other alternatives like the multi-court system, where you have better options where you can go to different institutions or even to legal service authorities, where you can resolve your disputes at the first level, so that the number of cases entering the funnel of litigation will be reduced. So rather than diverting the people from the tunnel to outside, putting a sieve before you enter the tunnel would be, or enter the funnel would be much more effective. I'm saying as a long run to make the judicial system more effective and to give quality time for litigation. So you need to have a sieve system where you prevent parties from coming into litigation, and those things can be wonderfully managed by the legal service authorities if they can do a good job. But added to that, I would like to add one more thing, because the mediators, see, when you're looking at mediators, you have to have mediators of outstanding quality, and of course we do have outstanding mediators, but see, they should be the corporate world or the business community should be confident to appoint them, because see, nowadays what happens is mediators are appointed based on references, because see, one council will recommend a mediator, or the court refers the matter to a particular mediator because the court is having confidence. See, likewise, it is all personalized references to mediation. But in a corporate world or a business world who does not have the access to personal references, they should appoint mediators on their accreditations. So these type of uniform accreditations which will evolve the profession of mediation apart from a passion or apart from a part-time profession, because see, most of the mediators are part-time professionals because they have other jobs like lawyers or other professionals who do mediation as part-time. That has to change, and the mediation as a profession has to evolve. And that is exactly why, in fact, last year, Justice Nariman, along with 5 other Chief Justices and former judges of different countries, had inaugurated the Asia Pacific Center for Arbitration Mediation. And that was an attempt made by all these institutions. There were about 9 institutions which joined the APCAM. The idea was to accredit mediators and arbitrators under a strict system, and to empanel them into the system, so that the people who are selecting mediators or arbitrators can be assured that in all countries you have the uniform pattern of mediators, and they do it under the same system and under the same law. So the goal of creating a credible system, I think, is mandatory, and it should not be confined to the domestic disputes alone, because you can't have a parallel system for international and a separate system for domestic. You need to cater the disputes which are domestic as well as international, and you need to put the system into a perfect system where the mediators can be, or see, when Dr. Dilip was saying, see, we need to create lawyers for the future, and the mediation advocates, like the litigation advocates, we need to have a parallel stream. But at the same time, you need to have professional mediators who are full-time mediators. You can't afford to build up a profession where the payment is not good and you can't survive as a professional. No profession will survive like that. So if you are keeping mediation all the time as an ad hoc system and a pro bono concept, it will not grow as a profession. It will always remain as a part-time profession with some people like us who are passionate to continue in the profession. But to continue to attract youngsters to join the profession as a mediator, as a professional mediator, it should be an attractive profession. And to make it an attractive profession, your jurisdiction of practice should not be confined to India alone. If you're taking India, as a mediator, your presence should be known it should be a global profession where anybody from anywhere in the world can choose them. So unless you make that, then there is no point in saying that mediation is a good option. Yeah.
So thank you for your comments, because there was the same thoughts that you just outlined here. Somebody in the chat box has said that this has to be, mediators have to be doing this as a profession and a passion, and not, on a pro bono basis or on an ad hoc basis. So thank you very much. I wish we could continue this conversation, but we don't have much time left. I'm going to now invite Brian Bannon and Ishan to give closing comments before we leave for today. And I thank you very much to all the panelists and also our regional collaborating entities. Thank you very much.
Thank you so much, Jaya. And I mean, I can't say too much about this discussion because it was just simply fantastic and quite informative. And it's perhaps quite great with the kind of perspective we got on mediation with experts in mediation, and definitely a good wrap to talk about mediation as a part of ADR, which is the part of our journey here, ADR as a global force for good. And it was in fact great that, in the previous session for the day, we created a segue to move into mediation. There were corporate councils talking about mediation from a business perspective, and then to have this broader discussion on mediation as it exists in India and the future that we can be looking at. So, as all great things must come to an end. And while this India leg of the World Tour does come to a close here, this is only just the beginning in a new dawn as we begin to move out out of the pandemic in the near future. And India is becoming a key player and influencer in this evolving world. And with all that we have learned over these last 2 days, India continues to grow in its readiness to use ADR as a global force for good. Brian, our colleague, is here. Brian, for everyone to know, is the mastermind behind this ADR World Tour. Thanks so much, Brian. The stage is all yours, please.
Well, thank you, Ishan, and thank you, Jaya, and thank you to all of our panelists, especially Justice Bhat. I know that he has a busy docket, and so we appreciate the contributions from everybody. My name is Brian Brandon. I serve on the Chartered Institute of Arbitrators North America Branch Board of Directors and its Young Members Group Steering Committee. It is my pleasure to conclude week 6, organized by my central organizing group colleagues, Jayara Sharma and Ishan Madan. We have 18 central organizing group colleagues who are organizing 11 webinars throughout the world. India's week 6, we began in Asia, followed by the Caribbean and Central America. We were in South America. We then moved to Africa and Europe. We're in India. Next week, we'll be in China, Scandinavia, before the Middle East, Turkey, and CIS and Eastern Europe, back over to Australia, New Zealand, and concluding in North America. As Ishan mentioned, we'll have a publication at the end of the World Tour, which will give a comparative analysis of ADR and access to justice, ADR as a means to strengthen the rule of law, and ADR as an efficient alternative to traditional litigation. In this India series, we've covered international investments, model BITs, business resilience, mediation. We've talked a little bit today about some of the Commercial Court Amendment of 2018 and what mediation and ADR looks like in the future of India. So I want to thank you, all of our distinguished panelists, again, Ishan and Jaya, for organizing, and we hope to see you on the next leg of the Chartered Institute of Arbitrators Young Members Group World Tour.